Good afternoon, everyone. Thank you so much for joining today's webinar on global considerations for intellectual property rights, which is part of our 2022 Export Week series of webinars. My name is Melissa Grasso. I'm with the U.S. Commercial Service in our Connecticut office. And the U.S. Commercial Service, for those of you not familiar with our agency, is the lead trade promotion agency of the U.S. Department of Commerce. One really quick commercial I'd like to start with. I'd like to highlight an upcoming program that the U.S. Commercial Service is leading, the Discover Global Markets program. The Discover Global Markets Business Development Forum is the U.S. Department of Commerce's flagship event series for U.S. exporters. This series will feature a dynamic mix of plenary sessions, topical roundtables, pre-scheduled one-on-one meetings with U.S. commercial diplomats, buyers, and ministry officials from key markets around the globe. And plenty of networking as well, all focused on the blue economy and marine technology sector. So definitely encourage folks to take a look at that program if you fall within those industry sectors. And also at the end of the slide, you'll see a link to a website where you can connect to your local U.S. Commercial Service office. We have over 100 offices across the U.S. So definitely encourage you to connect with your local office if you haven't done so yet. A couple quick housekeeping items before we roll into the meat of the presentation. All participants will be on mute for the duration of the program. We will be sending out a recording following today's live program. And importantly, all Q&A should be entered through the Q&A feature, which you'll see on the bottom right portion of your screen. When you enter a question, please do enter it for all panelists. Versus for one individual presenter, so we can all see those questions. Again, that's at the bottom right corner of your screen. I'd like to extend a huge thank you to our two expert speakers we have today, Elizabeth Galletta and John Mutchler from Murtha Cullina LLP. Elizabeth is a partner in Murtha Cullina's Business and Finance Department. She's also a member of the firm's intellectual property practice group. She represents a variety of clients from a variety of different industries in all aspects of intellectual property law. Elizabeth also serves as chair of the Privacy and Cybersecurity Practice Group, and she's also a newly appointed member of the Connecticut District Export Council. Elizabeth's comprehensive practice includes procurement of intellectual property rights and transactional matters surrounding intellectual property rights. She has extensive experience in patent procurement for clients in a variety of technologies, in the chemical, biological, and mechanical arts. Our second speaker today is John Mutchler, who's a partner at Murtha Cullina's Business and Finance Department, a member of the Intellectual Property Practice Group, and chair of Murtha Cullina's Diversity, Equity, and Inclusion Committee. His global practice includes patent protection and reexamination procedures, IP licensing, U.S. government and private company contracting, copyright and trademark consulting, as well as litigation and IP due diligence in bankruptcy proceedings, asset purchase and sales agreements, business formation, and mergers and acquisitions. John is also a professional engineer registered to practice in Connecticut. He has been an adjunct professor of law at Western New England University School of Law, at Rensselaer Polytech University, and at the University of Hartford, where he taught IP licensing, and entrepreneurial courses. So obviously we have two very, very wonderful speakers today with lots of great experience. And with that, John, I will turn things over to you. Thank you so much.
Thank you so much, Melissa, for that wonderful introduction of both of us. It's a pleasure to be here once again to do this IP presentation during Export Week. So let me jump into my first presentation on trademarks. So I'll move forward to the trademark slide. So I'm going to talk a little bit about both U.S. and international trademark protection. One of the most important takeaways about a trademark is, of course, knowing what it is. And a trademark is an indicator of the source of the goods. It tells you who the product or the service originates from. And it basically can be a word, a color like brown for UPS, a icon like the Apple, or it actually could be a chime like the Siri chime. So it really could be anything that when you look at it, you see it, you hear it, it's an indicator to you of the source of those goods or services. So how do you get protection for a trademark? Well, all you have to do in the US is start to use that trademark in interstate commerce. You don't have to go ahead and file a registration for a trademark, because you automatically get what we call common law rights just by the fact that you're using it in whatever particular geographic area you're talking about. When I talk about geographical area, I'm thinking of United States versus a foreign country, that you'd have to use the trademark in that particular country, in that jurisdiction. Like I said, you don't have to file a registration, but if you ever went to enforce it, you have a lot more rights if it is actually a registered trademark. And that's when you could use the symbol circle R, like I have here in the presentation, to indicate you have a registered trademark. If it's not a registered trademark and you're just using the trademark in commerce, you can't use the circle R, but you can just put a capital T, capital M for trademark in the upper right-hand superscript, like right about here, for your particular trademark. So if you file a trademark application in the United States, you get protection for the entire country. And it's limited, though, to the goods or the services that you specify in the application. When you file an application, the examiners will search for existing marks that have been either filed and are pending before you filed yours, or have already registered. But for example, if Nike filed a trademark for Nike for sporting goods, for example, or golf clubs or something, then the examiner would search in those fields of goods. There's actually a trademark for Nike for hydraulic jacks and pistons, but nobody would confuse Nike's range of goods with the use of Nike for hydraulic jacks and pistons. So, and how long does it take? So you file an application in the United States for a trademark, and if everything sails through, it could take about 6 months or so to get your first what we call office action. And what we suggest is that before you file a trademark application, you have a search done, a knockout search at least, to make sure that you're not going to get blocked by someone else's either registration or pending application. And once you get an office action, then you've got about 6 months to file a response, or it goes abandoned. So what happens after that? So at some point, if everything is clear and sails through the United States Patent and Trademark Office, then they issue what's called a notice of opposition. So they publish the mark in the Federal Register, and there's a initial period of 30 to 60 days for your competitors, anybody who's out there that has standing, to oppose or challenge the mark. And I'll talk a little bit more about the opposition proceedings later when we get into enforcement. One of the things that I wanted to note is that when you file a trademark application, you could either file it on what we call an intent to use basis, which means that you're not yet using it in interstate commerce, but you intend to at some point in the future. At that point in the future, or originally, if you're using it when you file a mark, you've got to provide what we refer to as a specimen. It's evidence of how you're using that trademark in interstate commerce. So, for example, if you had a trademark for a pump, then the trademark has to appear either on the packaging for that pump or on the product itself. It's not sufficient to have just an internet web page or whatever that uses the trademark and shows a photograph of that particular pump. So they're outside of the US, you can, the thing is, look at where your market is. So if you do a lot of business in China or Europe, then it may be worthwhile to file trademark applications in those countries or jurisdictions, so to speak. Most countries, each country has its own trademark office, which the applications can be filed in. But there's an exception, which is the European Union, which you can file an application referred to as a community application, and it gets coverage in all the countries in Europe. Most other countries outside the US don't have that requirement where you have to provide that specimen to show you're actually using the mark in commerce. So that's just kind of a quirk between the US and the other countries. I think I covered this. There's also in addition to filing in each country jurisdiction directly, you can file through WIPO, which is the World Intellectual Property Organization, and file through what was referred to as the Madrid Protocol. But you have to have a corresponding application in another country, for example, in the US, before you can file it. And if you're filing in a lot of countries, it may make more sense economically to file through the Madrid Protocol for an international application. What's good about trademarks is they never expire. As long, remember I said it's all about use. As long as you're using the trademark, then you have rights in it. So as long as the company continues to use the mark in interstate commerce, then it's valid and in force. You do have to file what we call a renewal every 10 years that you have to include proof, your specimen of use, and attest to the fact that you've been using it continuously for the previous 10 years or so. Just some little tidbits of information. Here's an example of a US trademark that was filed in May of 1884, and it's still in use and pending, and still in use in the US. And if you look at the UK, it's trademark number 1, filed in January of 1876 for Bass Ale, which is still in effect and in force. So with that, if there's any questions on trademarks, let me just take a quick look at the Q&A here.
No
I don't see any Q&A on trademarks, so I'm going to turn it over to Elizabeth to cover patents. There you go.
Great. Thank you so much, John. I'm going to take the next 15-20 minutes or so to discuss US and foreign patent protection for your invention. So the first question I'm typically asked is, can I get a patent? And so under US law, to get a patent, you must have a new, non-obvious, and useful invention. It needs to be more than an idea. That is, you need to be able to provide a written description of your invention and how one skilled in the art could make your invention and use your invention. One example I like to give is an idea is, I have an idea, or my invention is a flying machine. It's a personal flying machine. So I don't have to get on a plane and go somewhere, but I can just fly somewhere individually. And so my question to the inventor would be, well, how do you make this flying machine? How are the parts attached to one another? How do you use it? And you would need to provide me, in order for me to write a patent application, all of the various configurations, the attachments, and how you would use that flying machine in order for me to be convinced that you have an invention. Typically, outside of the US, they're looking for the same thing, a new, useful invention. Typically outside of the US, you might hear the term inventive instead of non-obvious. So you have to have an inventive step, meaning that you have to take into account what the problem is in the field of your technology and what problem your invention is solving. Similar to trademarks, patent rights are territorial, meaning if you would like to have patent protection in the US, you should file a patent application in the US. If you believe that you have either a market overseas or competitors overseas, you should take a look at those jurisdictions and make a determination whether or not you would like to file a patent application in one or more of those jurisdictions. Once you secure patent rights, a valid patent allows its owner to exclude others from making, using, selling, or importing the invention into the country that you have a patent in for a limited time. Typically, it's 20 years from your earliest filing date of your patent application. The US is a first inventor to file jurisdiction, meaning if you have two inventors who are separately working on an invention and one of them files a patent application in the US Patent Office prior to the other inventor filing an application for the same invention, the inventor who first files his application with the USPTO would win. The US also has a grace period. This might come up, and you might be familiar with this, because a lot of people are concerned about disclosing their invention outside of their company. This is in contradiction to trademarks. You get trademark rights when you use your trademark. In patents, the general advice is that you keep your invention a secret until you file an application. In the US, we have a grace period of 12 months, meaning if you disclose your invention today, May 5th, 2022, you have until 1 year to file a patent application at the USPTO. Of course, anyone else who first filed an application for a similar or the same invention would have subsequent rights over your application. But in theory, you do have 12 months, meaning your disclosure will not be held against you in terms of the patentability of your invention. Given that the US does have the first application to first inventor to file, and also because other jurisdictions that you might be interested in might not have that grace period, we typically recommend that if you are interested in filing a patent application for your invention, we recommend filing a patent application prior to the disclosure of your invention. And also, a disclosure should be broadly understood to be a sale or just an actual verbal or written explanation of your inventor to another who is not obligated to keep that invention a secret, either contractually or by employment. So if you are disclosing your invention, we would recommend doing so only as necessary and doing so under an NDA. Of course, various reasons might change our recommendation. So we would, if you have an invention that you're considering filing an application on, we would recommend that you talk to a patent attorney to figure out the best strategy. Let's see. In the US, there are several different types of patent applications. A provisional application, a non-provisional application, and a design application are some of the common ones that you might hear. Provisional applications and non-provisional applications are utility type applications. Utility type applications cover the use or the function of an invention, whereas a design application covers visual ornamental characteristics that are embodied in or applied to an article of manufacture. One example I like to give is a Nike shoe. Nike often applies for a design patent for the look of a shoe sole because it is ornamental, but they might also apply for a utility application because the sole has a new function. It makes you jump faster, run longer, something that improves upon the prior art. Once you file your application, similar to a trademark, the USPTO takes your application, and it's a longer process than the trademark. We typically estimate a patent application to be pending at the USPTO, depending on your technology, between 3 to 5 years. Some are faster, unfortunately, some are slower. The USPTO is divided, has an examining core, and those examiners are divided into groups, and those groups are based on different technologies. And depending on which group your application is considered to be relevant to will depend on how fast you will get your first office action. So you file your application, you'll get a filing receipt, and then you might wait up to a year or more to get your first office action. And the office action in the US will tell you what prior art the examiner considers to be the closest to your invention. And the prior art consists of any patents, patent applications, text, journal articles, websites that relate to your invention. The examiner will typically, I would say 95% of the time, make a rejection stating either your application is lacking novelty or lacking inventive step or is obvious over certain pieces of prior art. You have a period of time to respond to those office actions. Typically it's 3 months, and then another 3 months you can extend it and pay extension fees to respond to the office action. When you respond to the office action, you typically make arguments as to why the examiner is incorrect in their rejections. And you also have the opportunity to amend the application to further clarify and define your invention. What you can't do in a response to the office action is expand the scope of your invention. So when you write your application or you work with your patent attorney to write your application, you want to think of your invention in the broadest sense possible, meaning you want to start with how big in scope can you go with your invention, and then have certain, we call them fallback positions. You narrow certain limitations or certain aspects of your invention to be very specific. So if the examiner finds something that discloses your broad invention, you can fall back to a narrower scope of your invention and to specific examples of your invention. So remember, when you're thinking of your invention and you're trying to put into words what your invention is, be creative, think broadly, but also give specific examples. So you can always have another place to take your claims or your description of your invention and make specific arguments to the examiner to overcome any rejections that you may receive in an office action. Now, this all takes place when you file an application as a non-provisional. This examination never occurs when you file a provisional application. A provisional application merely serves as a placeholder. There's many reasons why you would file a provisional application as opposed to a non-provisional application, but one example of filing a provisional application, at least in my practice, is when we work with a lot of academic institutions, and professors and students often go and make presentations at various conferences. or they want to publish a paper and a publication is coming out or the presentation is going on, and they decide, well, we do think this is patentable. We do want a patent on this. Why don't we file a provisional application? It saves the date, meaning if I file it today, everything prior to today is prior art, but anything after that, if someone else comes up with something similar tomorrow, that's not prior art because it's after the day that I file it. So a provisional application is a great way to handle or manage disclosures or sales of your invention. So you can file your provisional application and then you're given 1 year. And within that 1 year, you can work on your invention, you can say patent pending, and then you have to make a decision before your 1 year anniversary whether or not you want to go through that examination process we just discussed and file the non-provisional application. Some people do, some people don't. Again, it depends on your patent strategy, what you've learned over those past 12 months, and what you want to do with that invention. Okay. So that's all in the US. What happens overseas? So John discussed taking trademark applications into various jurisdictions and whether or not you are going to be using those marks. You have to take a similar view in foreign patent protection. There is no international patent. I've heard that term tossed around. I think what people mean when they're talking about international patents is that they're referring to the PCT application, which that's an international patent application. And it kind of is similar to the Madrid Protocol application that John referred to when he was talking about trademarks. The international patent application, or the PCT application, allows an applicant to file one application. They undergo a search, and then you decide which particular jurisdictions or countries you would like to obtain patent protection in. So for instance, if you know that you are interested in China, Japan, India, and Europe, it might make more sense to file this one international application, undergo a search, and then file national stage applications in each of those regions or countries. However, if you know at the outset, well, my biggest jurisdiction outside of the US is China, and that is it, it might make more sense for you to file directly into China without filing a PCT application. Like I said before, most countries out of the US don't have that grace period. There are a few exceptions to that rule, but we generally like to think that most countries outside of the US are absolute novelty countries, meaning that if there is a public disclosure of your invention by you or someone else before filing, you can obtain a patent. If there is a sale of your invention before filing, you can't obtain a patent. If there is a scientific publication of your invention prior to filing, then you can't get a patent on your invention. So when you're considering filing outside of the US, you should take care not to disclose, sell, or publish your invention. Similar to the US, foreign, both at the PCT level and in national stage of a PCT application or in direct filing in a foreign jurisdiction, you're going to undergo the same examination that you go in the US, meaning the examiner is going to take a look at your application, review the prior art, issue an office action. In different jurisdictions call those actions different things, such as a search report. And then you're given an opportunity to respond. You can respond in the US, you can keep that response and office action period going for a long time. It's just going to cost you money. But typically there is no absolute number of office actions in the US that you're given before they will deny you. You just have to advance the prosecution each time. In jurisdictions outside of the US, they will have a certain, depending on the jurisdiction you're in, they do have a certain number that you have to reach, and then you go to an appeal or a proceeding before a different board or a different examiner. In the US, you can appeal any final rejection at the Patent and Trademark Appeal Board. Let's see, I think that concludes my portion, but I see there was a question. John, did you take that?
Yes, I did. I
Yes.
answered that, yeah. And I think your slides answered it too, so.
Okay, great. Any other questions? You can put in the chat box. If a question comes up after the next segment, I'm happy to answer. John, I'll turn it back over to you.
All right, so. All right, I got control of the slides again. All right, so we've got the information already on trademarks and patents on how you obtain one, and what we refer to as the prosecution phase of applications and eventual grant. But what happens after that? So if you want to enforce your patent, you have what is referred to as the right to exclude others from making, using, selling, or offering to sell the patented invention. And that's an important distinction because it doesn't give you the right to trump other types of, say, federal requirements, such as Food and Drug Administration requirements, or FDA requirements, or any other type of federal organizations. It only gives you the right to exclude others from what I just discussed. And if a competitor or someone else violates these rights, then that's referred to as patent infringement. So the first steps of enforcing your patent is to provide notice. And notice can be done in a couple of different ways. One is what we refer to as constructive notice, where you mark the patent number on the product or its packaging. And that provides notice to potential infringers that that product is patented. The other way of providing notice is actual notice. And that actual notice can be provided through what we refer to as a cease and desist letter. So you would inform the potential infringer that you have noticed that they're selling this particular product, and that you have a patent for it in whatever jurisdiction. We're talking US right now. But before you do that, you really need to do a reasonable investigation. If it's a product, get a sample of that product, take it apart, compare it to the claims in the patent, so you have a reasonable assurance that that device will be infringed by the patent claims that you have investigated, have granted. So after that, you're hoping that they'll just back off and stop selling it, and then everything goes away. But if not, then you can file a patent infringement lawsuit. And patent laws are federal laws. So any patent infringement lawsuit would be in the federal district courts in the US. Let me talk a little bit more about that. So it's, like I said before, it is very country specific. If you want to enforce a patent in the US, it's got to be obviously a US patent. You can't enforce a US patent, say, in Germany. You would have to have had a European patent that was validated in Germany, or a German patent that you filed directly with the German patent office. So before you go ahead and decide to spend all that money on a patent enforcement litigation, it's very important to do a validity analysis on your own patent. Really test it to ensure that the patent office did a good job of going through and evaluating novelty and non-obviousness, because the first thing that's going to happen when you file a lawsuit is that the defendant is going to try to challenge your patent and invalidate it. So you want to be pretty sure that that defendant or that infringer is not going to be able to invalidate your patent as being not novel or having been obvious. Litigation in the federal courts are very costly proceedings and very lengthy proceedings. Literally, depending on the amount of sales, you could be talking hundreds of thousands of dollars just in the first 6 months of the litigation before you even get to any substantive issues about the patent, just all of procedural back and forth, answering complaints and that type of thing. One of the things that's also important is that a lot of folks have the feeling, or someone told them that if you have a patent, you can stop others from using or selling that product. Well, that's not the way the law works. What you are entitled to is damages in the way of monetary damages. So, for example, a reasonable royalty is what you are allowed by the patent law statutes. As far as injunctive relief goes, which means having the infringer stop selling it, that's really up to the court to decide. So it's not automatic. You really have to show and demonstrate to the courts that monetary damages would not be sufficient relief for the infringement. So what is patent enforcement? Well, if someone without authority, a license, for example, imports something into the United States or sells or uses the product which is made by a process patented in the United States, that is also considered infringement. All right, let's shift to trademarks a little bit. So you've got to establish the use of your trademark in whatever country you have. And one thing that we've noticed is that sometimes companies have distributors in different countries. And you should have a very tight distributorship agreement with those distributors to make it 100% clear that those distributors have no rights and ownership of the trademark that they're allowed to sell your goods on in foreign countries. All too often, distributors in foreign countries just without your permission go out and file a trademark for your trademark application in the foreign country for your trademark, and then you're stuck with trying to defend that or invalidate that trademark. Let's see what we have next here. So same thing with trademarks as in patent enforcement. Is the first thing to do would be to provide a cease and desist letter demanding that they stop use of the trademark. And then again, trademark law is federal law, so it means you're into federal courts through the complex and costly and lengthy proceedings in federal court. So I said before, if you're suing someone for patent infringement, the first thing that defendant or infringer is going to do is claim your patent is invalid. So there's several ways to pursue what we call an invalidity proceeding. You can do it through what we call an IPR, which is between the parties. So both the initiator of the invalidation proceeding has a say in why they think it's invalid, and the patent owner has a right to speak and defend why it is that patent is valid. The post-grant review process is similar to that. It just depends on when you initiate that post-grant review versus the IPR on which you would choose. And both of these are kind of administrative type proceedings. This one here, the re-examination proceeding, is what we refer to as an ex parte proceeding. So what that means is, if I wanted to challenge the validity of competitor's patent, I would collect all the prior art, put together pages and pages of arguments as to why that prior art renders that competitor's patent invalid, novel, obvious, and then as the filer, the requester, so to speak, of the reexamination, I get to file it, but once I file it, I don't have any other say. It's up to the patent owner then to defend that his or her patent before the reexamination division at the United States Patent and Trademark Office. The other way to do it is just go directly to court, directly to federal court, gather all your evidence, and go right after the patent. And this would be more of an offensive approach, where you're not doing this as a invalidity defense to an infringement lawsuit. This is where you're taking a more aggressive approach, where you're dragging the competitor or into court to get the court to declare ahead of time that their patent is invalid. So what about trademarks? So once you get a trademark registered, if you want to try to enforce it, you go through the cease and desist letter approach, and there's always going to be a debate on who started using the mark first. So it's very important for trademark owners to have good records of purchase orders, advertisements, anything that shows when they first started using that mark in interstate commerce. So, because that's always going to come up, whether it's through an opposition proceeding or before a court of law. So remember I mentioned before that once you get the trademark through the application process and you get the notice of opposition, the period for other competitors to oppose the mark, that's where this comes in. So you could, if you want to oppose someone else's mark, then you can file what we call an opposition proceeding and provide evidence as to why their mark should not be allowed. You could argue that it's generic or it's merely descriptive, those type of arguments. And that's all done before the Trademark Trial and Appeal Board, TTAB as we call it. Same thing could be done before the courts of law or the federal courts. One other thing to note is, even if you have a registration for a trademark, Circle R, you can still file a cancellation proceeding. Someone else can file a cancellation proceeding, and you'd have to it could either be based on failure to use the mark or on other substantive issues. And so after 5 years of continued use of your mark, it becomes incontestable, and it's more difficult to be able to cancel a competitor's trademark at that point. Here, I know it's lunchtime, and I'm putting up this. I don't know, what is this? Is this a hoagie, or is this a sandwich, a hero, or is this a footlong? Well, we used to represent Subway, and we filed the application for their footlong trademark for sandwiches. And we found that along the way, the trademark office found small companies somewhere in the Midwest that had 2 registrations for footlong mark for hot dogs. And we went ahead and filed cancellation proceedings against those 2 marks. Those 2 marks were then canceled because the owner didn't even respond to the cancellation proceeding, and we got those marks canceled by default. So then it clears through. We had to provide evidence that everybody knows a footlong. There's billions of dollars of sales around the world using footlong as a trademark. But as soon as the opposition period opened, there were 11 fast food chains that filed oppositions against the footlong mark. And it took several years to get them off and settled and everything. And then finally, there was one that just wouldn't go away, and it went all the way up to the Trademark Trial and Appeal Board, and there was a big public hearing on that. And eventually it was determined that the trademark footlong was generic for sandwiches, and they didn't allow the trademark at all. And just to throw in a little copyright, that wasn't my photograph of the I'm going to call it a hoagie because I never looked at it as a footlong as being descriptive, but I got that off of this website. So it's always important that you, from a copyright protection perspective, that you give attribution when you use marks, and especially in this case when it's merely educational, it's not that problematic. But there are a lot of entities out there that look very closely at people's websites and just want to they have bots and things like that that look for pictures that you're using on your website, and they'll come after you for copyright infringement if you don't have a license to use those particular photographs that you may have gotten somewhere along the way. So that really concludes what I was going to cover on enforcement and the trademarks, and I could see if there's any questions. Let's see.
Thanks, John and Elizabeth. I do see there was a question on patents, if there's a patent ADR mediation forum.
So how about if you sell the items outside the country and you want to create a patent for the US, can I obtain a patent in the US? Well, the issue there is if you want to file a patent application outside the US, you have to first file an application in the United States, and the USPTO will look very carefully at it, and if they think it's worthy, they will give you what's referred to as a foreign filing license. And then you can go ahead and file an application in other countries. If you decide to file a PCT application, like Elizabeth talked about on the international phase, then you can then enter national stage sometime later. So it's very important that if you want to get foreign applications, that you file first in the US.
Sometimes, John, you don't even have to file an application in the US. You can just file a petition for a foreign filing license. I know some companies do that. So that might be an option. It just depends on the situation.
Right. Thanks for clarifying that. Let's see. Is there a patent ADR mediation form?
I believe you can mediate patent disputes.
Yeah, I don't know that there's actually a forum, but you can get a mediator, and have, usually retired judges and such do that, and then you can try to mediate your dispute. If it's related to a license agreement, there may be a clause in there that requires mediation prior to initiating a lawsuit. So the general answer to that is yes, but not exactly a forum.
Another question came in from the previous, the same individual who asked about the US and foreign patents, clarifying that the product was created in an African country. And it sounds like in that scenario that a product exists, it's known. And I think the question would be, once a product is in existence outside of the US, can you file a patent application for the same product in the US? Or are you are you barred from getting a patent? And the answer, it depends on the situation, but typically that product outside of the US can be used as prior art against you in the US. So it sounds like you can't first use and exploit your invention outside of the US for a certain period of time, and then file an application in the US or any other jurisdiction and try to obtain further or additional coverage in terms of a patent in the US on that same invention.
And the foreign filing license,
Yep.
Also applies in that case. Yeah, I had a client years ago that was in Brazil and invented a product, and while he was in Brazil, filed a patent application there. And then he reached out to me in the US, and we had to go through all sorts of hoops, thousands of dollars of trying to petition and explain why it would have been okay to file, not have first filed in the US and not having gotten a foreign filing license. So in effect, we had a petition for a foreign filing license back in time. So it was a very difficult and costly process.
Thanks, John and Elizabeth. While we wait for more questions to come in, if I could jump in, I do have a couple questions from my end. I'll just remind folks that you can type questions in the Q&A chat on the bottom right part of your screen. So a lot of the companies that we work with, and you both have given some nice proactive tips, and a lot of the companies that we work with do proactively prepare in the intellectual property realm. If a company has done their due diligence, but they suspect that their IP is being infringed, whether they're at a trade show and they see someone using, their trademark or what have you, what is the best course of action? What are the best first steps that company could take at that juncture? And I understand this topic could probably warrant its own hour-long webinar, but what are first steps that a company could take in that instance?
You want me to start? Sure. The first step would be to gather evidence. Get photographs of their product that they're demonstrating. If they have brochures there, then get copies of that. If it's really a big deal, you can actually go to the courts and have request an injunction and have the goods confiscated. For example, in Germany, if a client had demonstrated a particular product at a trade show and found out that its competitor actually had patent protection for that patent owner in Germany could file an immediate injunction in the courts and have those products confiscated and pulled out of the trade show. So that would be the first step, is gather the evidence, reach out to whatever potential law firm, whether it's in the US or in another country, to determine what your rights are but typically you'd start with a cease and desist letter, and then turn up the heat, as we've discussed in my presentation today.
Elizabeth, anything you'd like to add?
Nope, I think John is exactly right. The evidence is the most important, I think, from our perspective when we first have that initial discussion with the client.
The only thing I would add too is, if you're aware of a patent out there in another country and you want to then go over there and try to sell or whatever, try to get a license ahead of time, so you're not wrapped into an enforcement issue. Just, see if you get permission, either whether it's limited permission to demonstrate it in that country and agree, for example, that you're not going to sell it in that country, but you just want to be there advertising it because that there's tons of customers from the US that are at this German trade show, for example. So there's ways to get, or at least request, some type of preemptive license ahead of time for a very limited use that you may have to pay for it and get that patent owner to agree to.
Thanks, John. And before we started the webinar, Elizabeth and I were chatting about whether you can patent a proprietary blend of ingredients. Elizabeth, is that something that you'd like to expand upon?
Sure. Some questions I often get from, I represent a lot of entrepreneurs, and some of those entrepreneurs have food-based or cosmetic-based businesses where they have a proprietary recipe, if you will, and they often ask, can I patent a recipe or my proprietary blend? And the answer is, just the short answer, general answer is yes, you can protect or patent a recipe or a proprietary blend of ingredients. However, if you should think about whether or not you want to, because the alternative to patenting something like that is to keep it as a trade secret. You can think of an analogy is like Coca-Cola. Their recipe is not patented, it's held as a trade secret. Trade secrets, which we didn't discuss today, but trade secrets are maintained indefinitely as long as it is kept a secret. So they're not limited to those 20 years, contrary to patents. So also, by patenting your proprietary blend or your recipe, you're giving competitors exactly everything you do in creating your final product, and you should consider whether or not you would like to do that.
Great, thank you, Elizabeth.
Yeah.
So we are just about a minute and a half, 2 minutes from the top of the hour. So I'd love to give John and Elizabeth, both of you, another opportunity to any final thoughts you have for the group. Again, this was a great presentation, chock full of really good information. But any final comments from you both?
Yeah, I guess my advice would be, if you're planning on spending the money to get protection for a trademark, filing an application for a trademark, filing an application for a patent, before you go down that road, have a search done. I've way too many times I've had clients tell me, oh, I know there's nothing out there like this, but then the next thing when you have a search done, the one thing comes to mind. There was someone who wanted to file a patent application for a French fry holder that had a little fold down cup for ketchup attached to the side of it. I've never seen it at McDonald's or Burger King. I know this is going to be good. So we said, no, come on, you got to get a search done. And sure enough, there were 3 or 4 patent applications already out there for a device that was just like it. So you get a search done, either for a trademark or a patent, before you go down that road.
I agree.
Great. Well, I'd like to thank you both, John and Elizabeth, again for sharing your expertise with us this afternoon. Very much appreciate it. And again, to everyone on the call, thank you for joining us. And we will be sending out the slides and the recording within 24 to 48 hours. So thank you so much. Have a great afternoon.
Thank you.
Thank you. Bye-bye.